Oh, he's coming back. Good afternoon, everyone. Welcome back. How are we feeling? Everybody enjoying today's programming so far? Good, good. That's what we like to hear. There were some great conversations going at lunch. We've had a great day so far, heard from a lot of different presenters on a lot of different angles of this topic. That's been really exciting. I've really enjoyed everything that I've heard so far, and I thank all of you, all the speakers, all the visitors, everyone for being here today. I also want to thank, make a shout out that I didn't make earlier to Hannah Dunham and other students from University Relations who have been taking photographs for us today. We really appreciate that. And to Consolidated and ProTech and the Theodore Roosevelt Presidential Library, all the people who are handling the recording and streaming today. That's really excellent. So thank you to everyone. I also want to remind everyone about the book sale table. If you haven't been, when you exit this room, it's around the corner to the right. Be sure to check that out and pick up any books that you may be interested in if you haven't done that. With that, I'm ready to go ahead and move right on to our next panel of the day. And so it is my pleasure to introduce to you today Steve Easton. Steve is the former president of DSU and practiced law for more than 20 years before returning to higher education as a professor and administrator. His research, writing, and speaking has focused on expert witnesses, effective trial advocacy, and professional responsibility. And with that, I'm going to turn things over to Steve. Thank you, Steve.
All right, thanks much, William. I'm going to give only very brief introductions of our incredibly distinguished panelists, because if you want to know more about them, you can see that in the program. And I'm going to concentrate on one. Well, first of all, I will tell you that you have 3 lawyers in front of you. And if that wasn't bad enough, so 3 lawyers who have actively practiced law for many years. And that may seem bad, but not only that, you have 3 law professors in front of you, and all of us have had the pleasure of teaching at law school. To my immediate left is Mark Squillace. This morning I met Professor Squillace. It was one of my life goals to meet him. He did teach at the University of Wyoming College of Law, and then I served for a while as dean of the University of Wyoming College of Law, but we missed each other. He's now at the University of Colorado Law School, and what I admire many things about Professor Squillace, but one of them in particular, I'm always impressed by law professors who practice a little law while they are. It's actually quite unusual to do that, and Professor Squillace continues to do some very interesting and important legal work as a supplement to his. I say supplement. Probably doesn't supplement his income. He probably does. Yeah, it's probably all it's all for free. I just think that adds a perspective to teaching that's really valuable. To my further left, to your right, is Chief Justice Scott Bales, retired Chief Justice of the Arizona Supreme Court. Chief Justice Bales has several times taught a course on separation of powers with a particular emphasis on presidential power, which is going to be the topic of our discussion today. So he is, both of them are quite qualified to discuss this topic. We had a little bit of email communication about a week, 10 days ago, as you tend to do on these panels. And Professor Squillace sent some slides, some of which you'll see today, and said, how many lawyers will be in the audience? And I said, probably the number will approach 0. And then I show up today, and the lawyer of my life, Christine Hogan, who I spent 15 years practicing law with, she was the senior partner. I was the very junior partner as we traipsed around North Dakota and other states in the upper Midwest, trying cases together. And when I say trying cases together, I mean she was on her feet, cross-examining and doing direct examinations, and I was occasionally sliding her a piece of paper. That was the extent of my involvement, but it's really fun that you're here, Christine. And so I don't know if there's any other lawyers, but there's a really good one out there, so we better be on our toes. I did, in a fairly abrupt manner, go from being the president of Dickinson State University to being the former president of Dickinson State University approximately 5 weeks ago. And the good folks at the TR Center said, do you still want to do the panel at the TR Center? And I said, this is a local joke that some of you will get. I said, oh, actually, I think I'm particularly well qualified now to talk about the limits of presidential power. So it's great that they did not. It's great that they didn't kick me off the panel. All right, so what we'd like to discuss with you is, in the context, almost all or all of our discussion will be in the context of Theodore Roosevelt's work in conservation as the President of the United States. As many of you know, he is considered the first modern president. And that means several things, but one of the things it means is that many historians, I think, agree that Theodore Roosevelt expanded or grabbed power in ways that had not been widely done by any other president, with the arguable exception of Lincoln, but he had a civil war to conduct. And we'd like you to think about, and this is the kind of thing lawyers debate about, even if we like the results of Roosevelt's, and I think in this room we almost probably universally like the results of Theodore Roosevelt's conservation initiatives via the expansion of that presidential power, are there any cautionary tales? Do we have to deal with any negative downstream consequences now of what has come to be a fairly widely practiced and at least somewhat accepted very powerful presidency and administrative and regulatory government? Again, I think it's fair to say that really started semi-permanently under Theodore Roosevelt. And we'd like to think about what are the consequences of that. So I've got a few slides I'm going to start with. These are from a course that I used to teach here to our honors students about this issue. Oh, I'm sorry. So we're going to start with a discussion of presidential power in the absence of congressional action. We are going to end with a discussion of presidential power in the wake of congressional action. But we wanted to start our discussion with presidential power. And by the way, that last issue, we'll talk, particularly Professor Squillace will talk at some length about the Antiquities Act. That's a very obvious issue in this. We're going to get there. We're not going to start there, but we're going to get there. So when we all went to civics classes, we learned that there are three branches of government, and we learned that Congress is responsible for determining the law, and the judiciary is responsible for interpreting the law, and the president is responsible for enforcing the law, right? I mean, that's the basic separation of powers that we learned about in grade school. So an interesting question is, and this is a completely made up Venn diagram. I mean, I'm not saying there's this percentage of issues, but there are a certain percentage of things the Constitution says the president can do this. I've taken out the slide that lists what they are. There's a lot fewer things on that list than you think there is. There are relatively few things that says the president can appoint. There are some things. The president can appoint ambassadors. The president can subject to the advice and consent of the Senate, can negotiate treaties. But it's actually a relatively, and there are a bunch of others, but not as long a list as you think. So that's the orange part in the northeast corner of the Venn diagram. And the Constitution also, at certain points, says the president and other branches of government cannot, explicitly says you cannot do this. But there's a whole lot of territory where the Constitution is silent. Now, I very much hesitate to say the next thing because a basic principle of public speaking is don't make claims when there's an actual expert in the audience. And Clay Jenkinson is an expert on Thomas Jefferson. I think it's fair to say that Jefferson is often portrayed as someone who said, I need authority in the Constitution in order to do it. Now, there's one big, huge exception to that, which is Louisiana Purchase, which it's hard to make an argument that the Constitution says he can do that. But I think it's fair, Clay, to say that Jefferson is portrayed as someone that says, I can do what the Constitution tells me to do. And nothing else. Yes. Yeah. And you know what? We're all adults. There's always an exception, right? I mean, but basically that was his view. Roosevelt, and I believe this is from his autobiography. Roosevelt said, I reject that view. My belief is that it's not only his right, but it is his, meaning the president's duty to do anything that the needs of the nation demanded, unless such action was explicitly forbidden by the Constitution or by the laws. So let's start our discussion with an interesting example of that, which is Pelican Island. Many of you who know a lot about Theodore Roosevelt know about, I'm sorry, I'm ahead of myself. This was led into really well by our last panel discussion before lunch. This is the number of executive orders per day in office of the presidents from Washington through Obama. So not total number of executive orders, number of executive orders per day in office. Look where the big jump is, Theodore Roosevelt. And as we learned just before lunch, many of them, not all, many of them had to do with conservation issues and with protection of our natural resources from exploitation. But this is the thing that I think is interesting about these discussions. I think it's fair to say that many of us who are TR fans are not big Wilson fans, right? And now look what happens once you expand that use of executive orders. Then Wilson comes along and does even more. Now, I should note that this is a very crude measure of executive authority because there are 2-paragraph executive orders and there are 200-page executive orders. So it's not a precise measurement, but it generally reflects that increase. Now let's get back to Pelican Island. I believe this to be a photograph of Pelican Island, a relatively recent photograph of Pelican Island. And as the story is told, so for those of you that are not familiar with this, bird feathers, I think the word is plumage, became very popular as a fashion accessory in the United States. And Pelican Island is rookery the right word? Where birds are born? Is that the right? Well, man, I'm hot today. I got rookery right. Very important pelican. I think it was brown pelicans, although these are white. Maybe they are brown pelicans. Maybe it's like bears. The black bears are not all black. And they were being hunted very aggressively. The federal government owned this island. And as the story is told, and I don't know. It probably didn't happen exactly like this, but this captures the essence of it. Roosevelt said to his legal experts or someone else, is there anything in the Constitution or the statutes that prevents me from declaring Pelican Island a federal bird reservation? And the response was no. By the way, this, for the 4 lawyers or however many there are in the audience, this is a frequent question from a client, right? Is there something that says I can't do this? And you look and you say, couldn't find anything. And so then Roosevelt says, all right, then, if that's the case, I so declare it. So that is the instance I'd like us to talk about as an example of a use of presidential authority in the absence of an action by Congress. And what do you think of it?
Well, first, I want to say thank you to the... Close? Good. I wanted to start by just thanking the organizers of the symposium and just adding a little to Steve's introduction. As an Arizonan, I'm, of course, very sensitive to the significance of Theodore Roosevelt in many ways, and particularly with regard to conservation, not just his establishment of the Grand Canyon as a national monument, but other measures he took. You know, the growth of Arizona very much reflects the creation of the Roosevelt Dam, and that underlies the growth of the metropolitan area of Phoenix. Earlier today, people commented on Roosevelt's tour of the nation, and his stop in the Grand Canyon helped fuel his support as president for conservation measures. If you take me aside later, I can tell you why the Rough Riders are called the Rough Riders, and that too relates to Arizona. And I settled in Arizona 40 years ago, in part because I love the outdoors, and the opportunity to come and be part of a conversation about Theodore Roosevelt, conservation, and presidential powers was just hard to resist. So thanks again for the opportunity. Steve earlier showed a slide that distinguished it for the president powers that are expressly granted, things that are prohibited, and areas on which the Constitution is silent. His talking about Pelican Island raises one point that he didn't expressly say. So when you're looking at presidential action, you also need to consider whether Congress has spoken through laws. And sometimes Congress can expressly authorize the president to do things. Sometimes Congress prohibits the president from doing things. But if you're trying to gauge, did the president act properly, you have to consider that in addition to what the Constitution says. You also have to look at historical practices that preceded the presidential action, and you have to look at the immediate circumstances. Pelican Island is perhaps also illustrative that way, because at the time that Roosevelt did this, there wasn't a statutory prohibition, as Steve said, and there had been something of a practice of presidents taking action to protect public resources absent express authority by Congress. So you could say, well, there was an implied power that had been accepted over time. And when we think about Roosevelt's actions today, it's also important to remember that there have been some subsequent changes in the laws, and I think we're going to talk a little more too about an example with respect to the creation of national forests. So if I were to answer the question Steve posed, what do you think about what Roosevelt did? I think in the context of the time, given the legal background that existed, given the circumstances that we saw as a nation, we had pretty much eliminated the frontier in the continental United States. We had seen industrialization. We had seen the near extinction of things like the bison, as discussed earlier today, the elimination of bird species like the passenger pigeon. I think a president conscious of his responsibility to protect public resources in the absence of a statutory or constitutional prohibition on his acting would be within his authority. And I'll confess, I share President Roosevelt's view of a stewardship obligation on the part of the president with regard to the national interest.
Let me just add a few words. Two things. One, there is a property clause in the Constitution. It basically says that Congress shall make all needful rules and regulations affecting public property. And so one could have made an argument, I suppose, that indeed President Roosevelt did not have this authority. But that leads me to my second point, and this came subsequent to the Pelican Island designation, but there was a legal challenge in a case called Midwest Oil, where the question was whether or not the president had implied authority to set aside lands for things like Pelican Island. And the Supreme Court said that indeed the president had that implied authority. So you didn't really need the delegation, I guess, to the president in order to do this. Midwest Oil was actually overturned by statute. We can talk about that a little bit later if you want, but it's a pretty interesting background, and there's some interesting things going on with the property clause right now, actually, because of a lawsuit that Utah just recently filed, and if there's time, maybe we can talk about that later.
And my end point on this discussion we have overly qualified speakers at this, because I was going to ask you, federal bird reserves became federal wildlife refuges, and I was going to ask you which state has the most. I've asked my classes that, and then guess and guess and guess, but it's actually North Dakota, largely because of the flyway and the number and its importance. We probably won't have time, Scott, for the discussion of what is sometimes referred to as the midnight forest. So I'm just going to throw it out there as something for you to consider. This is massively oversimplified, but essentially, some in Congress were getting frustrated with Roosevelt and his conservation work, and they decided that the Forest Service is part of still part of the Department of Agriculture, and they put into, as I understand it, the appropriations bill for the Forest Service, which Roosevelt needed to sign, a provision that, as of the signing of the statute, the president no longer had the authority to designate U.S. national forest. Again, this is massively oversimplified. So Roosevelt said, okay, I'll sign it, and he got a team together. I'll sign it in about 4 days, and we're going to designate all kinds of national forests between now and 4 days. And what I thought was interesting about that is, although we can debate it, and we did a little bit over lunch, there was room in the statute to do what Roosevelt did. It never was overturned by a court. I don't know if it was challenged. But it really was the exact opposite of the congressional intent of that statute. And so when people say you got to follow not only the language of the law, but also the spirit of the law, and that's an interesting one, but we want to stay on time. We like that reputation as the only conference that stays on time. So let's go to the Antiquities Act. And Mark, can you educate us about the Antiquities Act?
Pull up that.
So we're going to skip those other slides.
As we're loading up the slides, let me just say a couple things about. Fair enough. Okay, so I was going to start by just noting that I got interested in the Antiquities Act many years ago because I've been teaching in the natural resources law field for quite a long time. But it wasn't really until I went back to work at the Department of the Interior towards the end of the Clinton administration that I really sort of came to know a lot about the law, because I ended up working with Secretary of the Interior Bruce Babbitt on basically laying out and designating a bunch of national monuments that came right at the end. And I got so interested in it, I ended up writing about it a few times over the course of my career since then. So I thought it would be worth just talking a little bit about sort of how we got to the Antiquities Act, and it relates to this whole question of presidential authority. You can see some really interesting examples, and I like this slide just because it shows you the diversity of our national monuments, all the way from Rainbow Bridge National Monument in southern Utah to the Statue of Liberty. Go figure. Statue of Liberty, by the way, was originally managed by the Department of War, if you can believe that. That's an interesting story that I'm not going to talk about. Okay, so here's the law, and I've just sort of highlighted some of the key language in the law. The president gets to declare by public proclamation historic landmarks, historic and prehistoric structures, and the key language really has become other objects of historic or scientific interest situated upon lands owned or controlled by the United States. So it has to be U.S. land, or it can actually be land or water in the ocean all the way out to 200 miles. We can talk about that if you like. And they're proclaimed to be national monuments. That's how we get this phrase. They're supposed to be confined to the smallest area compatible with the proper care and management of those objects. Okay, so where did we get the Antiquities Act? Why did it come about? It was passed in 1906, so this is during Roosevelt's term in office. And you can see, Steve was just talking about the midnight forests, and there were many members of Congress that were really concerned about Theodore Roosevelt being president at the time that the Antiquities Act was passed, because they had seen what he did with the National Forest, and they were concerned that he was going to try to do something similar to with the Antiquities Act if he got that authority. But there was this big debate going on between kind of Interior and the Congress. So John Lacey was the chair of the committee, the House Committee on Public Lands. He was kind of the leading authority on this issue from the congressional side. And he was being buffeted kind of in different directions, but he ended up sort of taking what came from the Interior Department. And here was the problem. Some of the early bills would have limited national monuments to something like 320 or 640 acres, about a half a square mile or a full square mile. But Interior, and particularly Binger Herman, who was the head of the General Land Office, the predecessor to the BLM, and then later W.A. Richards, who succeeded Herman, they, on behalf of the secretary really, they were pushing for congressional authority so the president could designate national parks. So there was this big divide. Small archaeological sites, sort of what we sometimes call postage stamp sites, relatively small square sites where a ruin might be found, or something bigger. And the compromise that ultimately came out, that was written by Edgar Lee Hewitt, who was the principal author of the final bill, came up with that language which I just showed you. And the key thing was it included this language that had been there from fairly early on about objects of a scientific or historic interest. And it's a sort of a provision for which you can designate lots of big monuments. And so I want to just talk about a few of the controversies that came up in the passage of the Antiquities Act. And I think Steve mentioned the Cameron case in the Grand Canyon. So the Grand Canyon was one of the earliest monuments that was proclaimed by Theodore Roosevelt. It was over 800,000 acres in size. And it led to the first case, the first lawsuit challenging a national monument. And to my mind, it's what secured the sort of legacy of the Antiquities Act and the ability to designate these really big monuments. A couple of other controversies I'll mention briefly over the Mount Olympus National Monument and also Jackson Hole National Monument. Bears Ears and Grand Staircase are still ongoing in terms of the controversy. But let's turn back to the Cameron case. So here's what the Supreme Court says. When Cameron comes in, there's a great story about Cameron that one of us can probably share with you, but let's hold that for now. But basically, Cameron's arguing that this can't be the smallest area compatible with the protection of the object. And the U.S. Supreme Court says, hey, wait a minute, this is the largest eroded canyon in the United States, maybe anywhere in the world. It looks like an object of scientific interest to us. The fact that it's 800,000 plus acres, it's still an object of scientific interest. And so from this decision, we really get this notion early on that what we call landscape level national monuments are authorized under the Antiquities Act. It's probably, or it may not have been something that Congress actually had in mind when they passed the Antiquities Act, but that's how it's been interpreted, and it's been used that way ever since. Another really important monument designated by Roosevelt just 2 or 3 days before he left office was the Mount Olympus National Monument. Big controversy over it. It wasn't litigated, but what happened here was that Roosevelt designates over 600,000 acres. Woodrow Wilson comes in and he's under pressure from the mining and logging industry and from the Forest Service and arguably from the war effort in World War I as well to downsize the monument. And they took out most of the forest land in this Woodrow Wilson proclamation. To my mind, that was illegal. We'll talk about that here in a minute, but it was never challenged. And so the monument was basically cut in half. Most of that land was restored when Olympic became a national park. And then Jackson Hole, this is kind of an important case. Sorry you can't see right the top part of that slide, but what happens in this Jackson Hole National Monument case is that President Franklin Delano Roosevelt designates the Jackson Hole National Monument because Lawrence Rockefeller had given a gift of about 23,000 acres of land to the federal government for the monument on the condition that Roosevelt designate this larger area for protection. But it was extremely controversial in Wyoming. The Wyoming legislators, they didn't want it. The senators and congressmen opposed it strongly. Cliff Hansen, who was a congressman at the time, ran his cattle for the monument in protest. to try to block it, but it did go through. They refused to fund it for a number of years, and ultimately they did fund it with the condition that there could be no new monuments in Wyoming ever again. It's the only time that the Antiquities Act was amended. What's interesting, of course, is the Jackson Hole National Monument, which is now part of the national park, has become extremely popular, of course, in Wyoming and throughout the country. And the people who opposed it now admit, or did admit later, that they were wrong to oppose it. This was a great thing for Wyoming. A lot of controversy still going on over Bears Ears and Grand Staircase. It's been a little bit back and forth on this issue. Obama designates Bears Ears, Clinton designated Grand Staircase. Trump comes in, he downsizes both of them in a significant way. There's litigation that's filed. I actually filed an amicus brief on the Grand Staircase aspect of the case. It's amazingly still pending in the federal district court in DC. The judge is Tanya Chutkin. If that name sounds familiar to you, she's the judge who's handling the case over the Trump effort to overturn the election. So kind of an interesting little sidelight. But why that case is still pending, I don't know. We worked on it a long, long time ago. But in any event, Biden reversed it all. So there's an argument, maybe the case is moot. She hasn't told us. We're kind of still waiting for the judge to say something about that. There's been additional litigation over this, and a big part of the issue, which I'll get to here in a minute, is whether or not you can modify or revoke a national monument that was created by a predecessor. And you can see from the green wording here, this is a link to a slide of an article that I wrote regarding the president's authority. Just a couple of quick slides for some pictures. So Peekaboo Gulch is in an area that was in the original Grand Staircase monument. It was out of the Trump monument. It's back in with the new Biden monument that we have. Bears Ears, similar kind of thing. This is a cliff dwelling in the Bears Ears National Monument, back and forth. Note, by the way, that when the monument was designated for Bears Ears, the claim was that there were over 100,000, or at least maybe up to 100,000 archaeological sites within the monument, many of which had not yet been discovered. And so the argument for Bears Ears, in a large way, was that it's a cultural landscape. And remember that Grand Canyon was designated as a monument, as sort of a scientific landscape. And it's kind of an interesting issue. We've talked about this in terms of biological or ecological landscapes as well. And those are the kinds of arguments we make these days. This is a headline from the Washington Post from a few years back about fossils that were found in Bears Ears in an area that had been removed from protection by the Trump administration. So this was one of the arguments that's being made in the litigation. The other thing that I just have to mention, I find this totally fascinating. When Grand Staircase was first designated, people knew that there were probably some good fossils there, but they didn't know the extent of it. And I just want to show you this photo. These are a bunch of photos that I took at the Utah Museum of Natural History. And if you ever have a chance, you're in Salt Lake City and you have a chance to go to this museum, it has some of the most amazing dinosaur skeletons that you will see anywhere. Some of these skeletons have never been found anywhere else. And almost all of them come from the Grand Staircase Escalante National Monument. It is one of the largest, maybe the largest in the world, dinosaur bed that anybody has found, and they're still discovering new skeletons all the time. It's really an amazing facility if you go there. The pictures don't do justice, but you can kind of get a sense for the things that you'll see there. Do I have time to talk about diminishing and modifying? Okay, real quick, we'll talk a little bit about whether the president can diminish. So here's the basic argument here. The Constitution, as I said, gives the president the power, or the Congress, excuse me, the power to dispose of and make all needful rules and regulations respecting public property. What's interesting about the Antiquities Act is it authorizes what I call one-way authority. It gives the president the power to reserve lands, but it says nothing about his power to take those reservations away. And the reason this is significant is because there are contemporary laws that actually do the opposite. They give the president the power to withdraw lands and also to modify or revoke withdrawals that were previously made. So one of the key legal arguments here is that Congress understood that if it wanted two-way authority, that it knew how to do that. And so it didn't do that in the context of the Antiquities Act. And I have argued that it's really important that we recognize this one-way authority. If a president can take away protections that a previous president had put in place, that land could then be compromised in significant ways. And so the protections that had been put in place could be lost. Congress can always undo those protections. But the argument is that a future president can't undo the protections that a previous president had made. And that's kind of where we end up. I know I'm out of time, so why don't I turn it?
You did great, Mark. Thanks.
Okay.
Thanks.
Yeah.
And Scott, we've kind of frozen you out of this. Yeah, so before we get to questions, I want you to. And by the way, I know it sounds disrespectful for a lawyer to refer to a Chief Justice of the Supreme Court as Scott. We go way back, following law school, different law schools. We both clerked for the same judge, and then I came back here and had those fun trials with Christine. And Scott had a good career move too, because he went from Judge Snead's chambers to clerking for Justice Sandra Day O'Connor. So he did okay. But that's why I can call him Scott, because we go way back. So what do we miss, Scott, before we get to questions?
Well, I'm not wearing a robe, so call me Scott. Just a few comments. First, as Mark's presentation reflects, the Antiquities Act, by its words, gives the president very, very broad authority, because it's up to the president at his or her discretion to determine whether to, by proclamation, designate something as a national monument. And while the statute talks about landmarks, structures, and other objects of historic or scientific interest, as Mark's comments about the Cameron case reflect, those terms have been read very broadly. So we have national monuments that range from things smaller than this room to hundreds of millions of acres of seabed off the coast of New England that's now part of the Eastern Canyons and Seamounts National Monument created by President Obama. Presidents have used this many times. There's 163 national monuments, I think, at this point, and it's been both Democratic and Republican presidents. Many of the largest areas of designated national monuments were actually established by President George W. Bush in seabeds in the Pacific Ocean. Third thing, for a statute that is so brief and has existed for so long, it's stunning that it has not really been the subject of interpretation by the United States Supreme Court. But for that one Cameron case, there's really not another decision that fleshes out what these various terms might mean. So the controversies that we've are now seeing over things like Bears Ears or the Escalante Grand Staircase National Monuments, they are partly still live, both because of the amount of land that's involved, but also because the Supreme Court's never chosen to clarify what limits, if any, there might be on the president's authority to declare national monuments and to reserve land. And the statute says the land reserved is supposed to be the smallest area compatible with the proper management and care of the resource. Well, you know, if you're thinking about things like Bears Ear, first, what's the designated protected resource? How much do you need to actually protect it? And the statute also leaves to the president discretion about what is necessary in terms of restrictions on use. So if something's designated a national monument, it doesn't carry with it even the necessary reservation of land, but it particularly doesn't specify what limits will then be imposed on use. So you have questions about, well, are mining rights going to be allowed, grazing, off-road vehicle use? And you might make the argument that all of those different considerations should either be made by a branch of government outside the executive branch, Congress as the body that's responsive to the will of the people, or you might also make an argument that at least the process should be more elaborate, that there be some requirement of public input, that the president be directed to consider various interests in making the decisions, or that even the ultimate restrictions should somehow reflect a concept of mixed use, as is true for other kinds of federal land policy decisions. But all of that has never been settled, and that's why today we still have cases in the district court in Washington, D.C. over whether the president can cut back on a national monument once it's been established. And I think I'll stop there.
All right, let me take the privilege to share, make 2 points before we get to questions, and they are related points. First, I think we all need to recognize that almost always, when a president, someone acting on behalf of the president or anyone else, takes an action in the interest of conservation, that will tell you what the word I wanted to make is. It's controversial. There is almost, or maybe I shouldn't say almost always, very frequently there is someone or some group of people or some industry or some entity that is very much opposed to that action. We sometimes forget that, and that point was made well this morning in history, and we look back and it's like, oh, of course everybody wanted the Grand Canyon, right? It seems inarguable that we would want the preservation of the Grand Canyon. It was highly controversial when it happened. And that leads to my second point before we get to questions. And this is the argument that Mark articulates, which I think is correct. We lawyers always caution, there's always an argument on the other side, but I think he makes the right argument that a future president cannot change the designation. That has to be done by Congress. That's relatively unusual because that's presidential action in the light of a congressional statute that calls for presidential action. In the absence of that, remember, it was controversial when it happened. And presidencies don't last forever. And in our political system, it is not unusual for one president to be replaced by another president who has very different views on issues like conservation. And so be careful. You know, what wasn't it, Karate Kid, when he's learning and they say, you know, I'm giving you this power and you can use it for good or you can use it for evil. I mean, I think we have to be careful about the power we give to a president, especially outside of congressional authority, because if the president does it, in many instances, it can be undone by a future president. I do think that the Antiquities Act, go ahead, Scott.
Well, and it occurred to me as Steve was talking, one way perhaps of thinking about the issue that Mark was talking about, whether presidents under the Antiquities Act can cut back on reservations. What would Teddy Roosevelt think about that question? And in a way, it's an echo of our talking about how do you think about presidential power? Is it something that exists unless it's prohibited? Or is it something that exists only if it's expressly granted? And I think perhaps, if you were imagining yourself in Roosevelt's shoes, you might say, well, it says I can reserve. It doesn't say I can't modify an existing reservation. But on the other hand, again, if you look at this statute in the context in which it was enacted, including the other statutes that then existed, you might ask yourself, well, but if it says may reserve, is the implication that that's all you can do? Or again, it comes back to, do you think a president can only do what he or she is expressly allowed to do? Or can they do things that they are not prohibited from doing?
And I would just add, I just want you to think about it in the context of the property clause. Because remember, that Antiquities Act didn't come out of thin air. It came out of the clause in the Constitution that gives Congress the power to make all needful rules and regulations affecting public property. And so I would argue that because Congress only gave the power to reserve, that's the limit of the power. Now, it's a debatable issue. I don't want to suggest it's not, but we'll see what the courts ultimately have to say about that issue.
All right, time for questions. It looks like you got the microphone for questions.
I just want to defend the 3rd President Jefferson and the 26th Roosevelt. So Jefferson was offered the Louisiana Territory. He thought it was unconstitutional because he was a strict constructionist. He actually wrote 2 constitutional draft amendments that would authorize the purchase and authorize the incorporation of the new states. And it was Madison who talked him out of it. So don't blame Jefferson. Number 2, but more importantly, Roosevelt. So under the Antiquities Act, the president has the right to designate these properties. Under the National Forest Act of 1881, he has the right to designate these properties. It's explicitly put in the statute. Roosevelt invented the National Wildlife Refuge System out of whole cloth in 1903, but you left out one piece that's important because he brought in Philander Knox, his attorney general, and his first question was, is there anything in our statute books that allows me to create a bird sanctuary? So he did due diligence.
Yep.
And then Knox said, no, sir. And then Roosevelt said, well, then, is there anything that prohibits me? Knox said, no, not as far as I know. And then Roosevelt said, I do declare it. So he did due diligence before he made that bold move. So, you know, back off, Steve, you know.
So, Judge Bales in particular, you obviously, as you were speaking about the Antiquities Act and the current situation with the Supreme Court, there's a lot of discussion obviously in our country about giving states more control. There's one women's reproductive issue in particular where this is a hot button issue. So that issue, I'm almost 48 years old, has been a topic my whole entire life, and now we've had a radical, a different ruling in front of the Supreme Court. Do you envision that the Antiquities Act at some point is going to face a challenge that is going to be similar, where the argument could be made, well, the state of North Dakota might not want a national monument because any number of issues are before them that might supersede or be more important than the presidential power, if you will?
It's a great question, but I think the answer is it wouldn't be answered in the way the court approached the issue about reproductive autonomy for women because, as Mark said, the federal Constitution expressly empowers Congress with authority over the control of public lands. So this isn't a question of whether the federal government, as the federal government, has authority here. But the court, as it's currently composed, has on the one hand been more skeptical about broad congressional delegations of authority to federal agencies. On the other hand, it's been more accommodating to claims of presidential power. And those are kind of in tension when you look at the Antiquities Act. So I don't think that that the Supreme Court would say that federal government can't say we're going to set aside federal lands for national monuments. Whether a court more narrowly read the authority that's given to the president under the statute, I think that's something that is an open issue.
Can I add something? That's a really interesting question, in part because about a week ago, the state of Utah filed a lawsuit in the U.S. Supreme Court, a very unusual move because they're suing the federal government in the Supreme Court. The Supreme Court does not have to take the case. Actually, they're going to need 5 votes before the court will take the case. It's not like what we call certiorari, where you need 4 votes. You need 5 to take a case in this instance. And Utah is claiming that the federal government basically doesn't own the federal land, what they're calling the unappropriated federal lands in the state of Utah. And I've been quoted in some of the news outlets about this case as being absurd and ridiculous, but that's not to say I'm not nervous about it. The reason I think it's kind of a ridiculous case is that Utah and every other Western state in the country specifically disclaimed any interest in federal lands when they became a state. It's in their Statehood Act. It's very explicit language. We disclaim any right or title to any of the unappropriated lands in this state when we become a state. And so sort of as a contractual matter, they don't seem to have a leg to stand on. And as I mentioned, the property clause seems to give the Congress all this authority. Utah's focusing on this word dispose of, or the phrase dispose of, in the property clause. And they're suggesting that that phrase is the only authority that Congress has, which is to dispose of the lands. They don't have any right to retain it. And taking their argument to the extreme, and they've made this point, they think the Federal Land Policy and Management Act, which specifically authorizes the federal government to retain the public lands, they think it's unconstitutional, or that's the argument that they're making. So your question is a live one, I guess I would say. I don't think the courts, even this court, is going to take up this case. I think maybe they'll send it back down. It'll probably be refiled in the lower court, but I don't know. I mean, we'll have to see what happens with that case.
Yeah, thank you very much. I really appreciate this panel. I just wanted to make a brief point and then ask a question that's very much in vein of the previous question, and that is that, in my view as a historian, this question of executive authority to establish national monuments and use the Antiquities Act, et cetera, is really bound up with the larger progressive quest to endow the federal government with the capacity to deal with what those people like Roosevelt saw as pressing national questions, and particularly to force the federal courts to recognize that authority. And so this comes out in other arenas that aren't centered on natural resource questions, particularly the regulation of labor and working conditions and anti-monopoly efforts, and as part of a larger progressive crusade to actually create a federal government with powers to do things that it arguably did not need to do before the United States became an industrial country. My question, I guess, is I'm curious for the three panelists' take on the present and the extent to which the federal courts are going to let environmental regulation broadly construed continue to happen, or the extent to which we're actually seeing a sort of reversal and, in some rough sense, a return to the judicial constraints that the progressives understood themselves to be clashing against. And I'm particularly, was struck by what I think it was, I forget if it was Mark or Scott. Scott, I think it was you, just pointing out the tension between, on the one hand, the Supreme Court that has given the president shocking powers, right, to engage in actions that he or she alleges are part of the office. And on the other hand, a court that has, in the Chevron decision, in the view of at least many environmental activists, limited the ability of federal agents to effectively implement a generation of environmental regulation. So that leaves me confused as to the current situation, and I'm glad that you all can clear up my confusion.
Go ahead.
Well, first, I think it is fair to say that the Supreme Court over the last decade has made a series of decisions that both involve statutory interpretation, or in some instances the scope of Congress's authority under the Commerce Clause, that would have the effect of limiting the power of the national government to address certain kinds of environmental issues. That's just the fact. A different point that I think is important to mention is that in a time of the inability of Congress to act, it may be, as a practical matter, all the more important that we have a president who can act, as Alexander Hamilton said, with energy and dispatch. And that's one thing that historically was true in terms of presidents acting under the Antiquities Act. They were able to take actions that might not have been achievable immediately in Congress, and that also reflected a longer-term perspective on the interests of the country, and perhaps a broader perspective not limited to a particular geographic constituency. And that once those actions were taken, over time they came to be accepted and came to be very popular. So I think it's important, if we are talking about what should the act allow, or how should we interpret it in terms of a broad or narrow view of presidential power, we ought to take into account how it has actually worked out in practice over time, and very much to the benefit of our nation.
Yeah, so just to build on something that Scott just said. There's a famous quote from Paul Begala. Does that name ring a bell? Remember, he was an aide to Bill Clinton about the Antiquities Act. He said, stroke of the pen, law of the land. Pretty cool. So if you want to talk about an efficient kind of process, that's all it takes is a signature from the president. But it does raise these other issues about presidential authority. I wanted to just point out two cases that I think relate to the question very much. One of them is West Virginia versus EPA, which is a decision from the Supreme Court where the Supreme Court essentially says that if we're dealing with what they call a major question, they call it now the major questions doctrine, then the agency has no authority to act unless they have a specific delegation from the Congress. And to be clear, Congress just doesn't typically give those kinds of specific delegations. So the impact of the West Virginia case is to deny the federal agency, in this case the Environmental Protection Agency, virtually all authority to act unless there is specific delegation from Congress. And this had to do with climate change and the authority of EPA to deal with climate change issues, and the court more or less took that away from them. And we don't really know what constitute major questions, but it seems like environmental issues are at the top of the list for this Supreme Court. So it's something to watch carefully. The other case I would point out that I think also signals some of the problems we're going to face is a case called Sackett versus EPA. They both involve EPA. The Sackett decision involves the interpretation of the Clean Water Act. And it has to do with the scope of the Clean Water Act. And without getting into a lot of details, the Supreme Court has basically suggested that the government has no authority over water, any water, despite language from certainly the legislative history, and I would argue from the Act itself, that suggests very broad authority to regulate pollution into our waters. But the court says in Sackett, and unless it's relatively permanent standing water, you don't get to regulate pollution into that water. And it's a shocking decision in lots of ways because, as we all know, there's a lot of pollution that comes from ephemeral streams and into groundwater and other kinds of things that presumably cannot be regulated after the Sackett decision. So it is, I think, true what the questioner was probably suggesting, which is the Supreme Court has really taken away from, in this case, the Environmental Protection Agency, a lot of the authority to regulate some of the major problems that we're dealing with in the pollution area. And it's something to watch. We're going to have to see how that goes. By the way, Congress could fix a lot of this. And as I think you all might know, Congress is essentially dysfunctional. Congress really can't do anything in a big way with important issues like this. And so I'm not holding my breath for Congress.
We are out of time, but no good lawyer will absolutely live with the judge's time limits. So I will just note that for those of you that are not from this part of the world, I've lived most of my life in what is referred to as the most unpopulated zone of the United States: western North Dakota, western Nebraska, eastern Wyoming. Nobody lives here. Something like 6% of the U.S. population is in the Mountain Time Zone, 6 or 7%. So for those of you that aren't from here, you may not be aware that all of those states have, as a provision of their state constitutions, the requirement that every citizen get up and at least once a day grumble about the damn federal government, right? And yet, we have this very interesting relationship with the federal government because we wouldn't exist without the federal government. All of those, I mean, Wyoming, they built the Transcontinental Railroad, and that's why Wyoming exists. And we don't like to admit this. Burn the tape before somebody can quote this, but we don't like to admit how dependent we are on the federal government. But then when the federal government starts telling us what to do, we get really, we talk very independently. It's just an interesting, and it's related somewhat to your, to the very probing question that was asked. And the other thing I'd ask you to think about when we talked about this at lunch, and Mike Cullinane came over and asked what what our topic of our panel was, and we said we're going to talk about the regulatory state and the administrative state and the power of the presidency. And Mike said, well, hasn't everybody pretty much accepted that now? And I said, well, no, don't go to a coffee clutch, you know, it's not. But what would the alternative be at this point in time? What would the alternative to a whole lot of federal regulation by government of experts, at least we hope? At this point in our history, can we put together an alternative to that? I think it's really hard to do. Let's thank our panelists for doing it.